So good morning, everybody. A little bit about Generations Law Group. We're an elder law and estate planning law firm in Sudbury, Acton, and Burlington, Mass. And we help folks with guardianships, conservatorships, estate planning, mass health applications, long-term planning. And Kathleen is one of our founding partners. She has over 30 years of legal experience. And she is our lead attorney on the estate planning and crisis planning. She's the go-to expert on helping clients and their families navigate the legal and healthcare worlds when a crisis occurs. Kathleen is often sought out by professionals to serve as an advisor to local hospitals and to be a member of boards in the community. She currently serves as president-elect of the Massachusetts chapter of the National Academy of Elder Law Attorneys. So Kathleen, what can you tell us about trust funding?
What I'm really going to focus on is trust funding for revocable trusts, as we call them. And anyone who has put a revocable trust together with us knows that I talk a lot about the fact that in order to really make the trust work for you and to do all of the things that you want it to do, we need to make sure it's funded. Otherwise, it really isn't giving you the full benefit that you are looking for in terms of the trust. So today's discussion is really talking about revocable or revocable trusts. We also call them living trusts. And these are trusts that you all control while you're alive. You are the beneficiary of, really for yours, and if you're married, your spouse's benefit in most cases. And the best way for you to maintain as much control during your lifetime as possible, while also planning, should you become incapacitated, for who will step forward to manage the assets for you, and certainly after your death, how the assets will pass. So I want to just start off real quick talking about, first of all, again, the myths about trusts in terms of why people oftentimes think, I don't need a trust. And then we're going to talk a little bit about the important definitions within a trust that you should know about. And then we'll talk about the funding itself. So a lot of things that we hear, trusts are not something that are needed for everyday people. They're only for the rich and famous, that they are only if you have very, very high net wealth. And that if you put things into a trust that you'll lose control over them, that they require separate tax filings. All of these things are myths when it comes to revocable or revocable trusts. And again, those of you who have worked with us to put those together know that trust can be a very useful tool to be able to ensure that assets pass without having to deal with probate. And for married couples, it can also help to reduce the estate tax exposure, particularly when the second dies here in Massachusetts. So again, the benefits of a trust, they can give peace of mind. They can allow for privacy. Remember, we talk a lot about probate and the probate proceedings when someone passes away and they have assets in their own name. They end up going into court, which is a public process and can be viewed by people. The trust allows for the privacy of the individual putting the trust together and for the beneficiaries. And again, it does avoid probate, which is really critical, particularly in today's climate. We're finding that the probate proceedings can take up to about 20 weeks right now to get somebody appointed, particularly in Middlesex County. And a lot of this is due to the COVID situation. The courts are still not functioning at full capacity. Matter of fact, they just opened up about a week and a half ago again to the public. So we really have seen a huge delay when we're dealing with probate assets, and funding your trust will make sure that you have avoided probate after your passing. So a little bit about the nuts and bolts of trusts. Again, some common terms that everyone needs to remember. The grantor or what we call sometimes the trustor or the settler of the trust, is the person who creates the trust. So typically that's yourself. You're the creator of the trust. You and or your spouse may have put a trust together. You are the ones who have set the terms of the trust, what's going to happen to the assets after your passing. The trustee in the trust is the person who's managing those assets. Now, in a revocable trust situation, usually the trustee is also the grantor or settler, the trustor. So you can be wearing multiple hats in a trust. If you are the creator of the trust for your benefit and you are the trustee, you are functioning in many of these different capacities and you are acting as trustee for your own benefit. A trustee has fiduciary responsibilities to the beneficiaries. So when someone is stepping into your shoes, whether it's after your death that they're taking over the responsibilities as trustee, or they're acting as trustee because you're no longer capable of managing your own trust, then they have a fiduciary responsibility to you and to the beneficiaries of the trust. The assets that go into a trust, and this is what we're really going to talk about today, is how we fund a trust and move those assets into the trust to ensure that the trust is properly funded and fully funded, meaning that you no longer have assets outside of the trust that are going to require the probate process to be handled by the courts after your death. Now, there may be some times that we do leave assets outside of a trust, and I am going to talk about that too, when assets should go into the trust, what assets should not go into the trust, and what assets you may choose not to put into a trust. And then there's the beneficiaries of a trust. Again, in a revocable or revocable trust situation, you are also the beneficiary of the trust. So you are the grantor, the trustee, and the beneficiary. But after your death, then certainly you have outlined other beneficiaries for that trust who are going to end up benefiting from the trust assets. And you could name other beneficiaries of the trust even while you're alive if you chose to. And oftentimes we see that with a married couple who have put together a joint trust. There are two beneficiaries of that trust. So those are some important terms to remember. Trusts are typically written in a more generic format. So oftentimes it can get confusing. You're reading the trust and you're saying, well, wait a minute. Why is it talking about the trustee in kind of a third party relationship, or the beneficiary as a third party when I am the trustee or the beneficiary? And we do that because, again, the trust is intended to be long-term, and we want to make sure that the wording makes sense regardless of who is serving in these different positions. And so it's important that it be a little bit more generic in terms of its overall kind of flow, so that no matter who's serving as trustee, their responsibilities to the trust are the same, whether it's you or whether it's someone else. So important that you, when you're reading the trust, you look at it that way and you understand these common terms. So let's really talk about, again, real quickly, we're really focusing here on the revocable or revocable trusts. As you know, there are a myriad of trusts out there. There are irrevocable trust situations, special need trust situations, and even specialty trusts like life insurance trusts, gun trusts, pet trusts. Those we are not talking about today. We are really focusing on that revocable or living trust situation. So the benefits, as you all know, of the trust, one of the first things is to avoid probate. That's why it's critical that we make sure that the trust is properly funded and that assets are transferred over during your death. During your life, my apologies. We do have a safety net in place, though. Your will is typically what we call a pour over will, so that if there is an asset that ends up being left outside of the trust, upon your death, The will require then probate in order to be able to control that asset, but it directs that the asset get fed into your trust so that the trust is the controlling document for your estate plan. So even though we have the safety net in place, our goal is to avoid it and to make sure that we don't end up having to utilize the trust as a way of being able to have to go through probate. We want the assets to be controlled by the trust directly. Remember that trusts can go on after you as well if you choose to, if you have minor children, if you have beneficiaries that you want to ensure either never control the assets themselves directly or control them only at certain stages in their lives. And sometimes we have beneficiaries who may have some kind of special need, or maybe you're worried about their marriage situation and whether they may get divorced in the future, or creditors, and the trust can go on even after your passing. So I want to go on to the issue of trust funding itself. And again, what do we look to put into a trust? So we really break things down into a couple categories. We have your investment and bank accounts that we want to put in, your personal property, and then your real property, real estate, and whether it be here in Massachusetts or whether it be located in another state. We want to make sure that these assets are properly titled into the trust in order to keep them safe and to fully fund that trust vehicle. So let's talk about retitling your assets into the revocable trust. And as I said, we really look at those assets in three different categories. We have your bank accounts, your investment accounts, kind of your, what I think about in terms of your monetary value and how we want to get that into the trust. And the things that you want to think about being put into the trust are your savings accounts, potentially any other cash or investment accounts that you may have. Things like individual stock. If you own individual stock, we want to make sure that those are going in. So again, we're talking about your financial accounts, looking to put in cash accounts, investment accounts, individual stock. They need to be transferred into the trust as well. We're looking to put your personal items into the trust. We're looking to put your stuff into the trust so that things like furniture, clothing, etc., don't end up having to go through probate upon your passing. And we're looking to put real estate into the trust. And some things to remember about real estate: it's not only your primary property that we're looking to put into the trust, but we're also looking to put in second homes that you may have, homes that may be located in another state. That's critical to get into your trust, because if you own property in another state, including timeshare property, then it may be subject to probate upon your passing. And so again, one of the key things we're looking to avoid here when we do any kind of trust planning is to avoid the probate. So we want to put all of these assets in. If you own, thank you, Carol, by the way, if you own any kind of business, right there, Carol, thank you.
Yep.
We also want to look to get potentially your interest in that business into the trust, whether that be a partnership interest that you might have, or you own a personal corporation, you own an LLC. We do want to look to assign your ownership in that trust, or in that business, into the trust. If you're expecting an inheritance, there are sometimes ways that we can direct those assets into your trust ahead of time. It does require some coordination with whoever you're receiving the inheritance from, but there are oftentimes some things that we can do to ensure, should something happen to you before the inheritance is received, that it will end up flowing through your trust. And if you have a lawsuit judgment that you are waiting on, something like a personal injury claim, let's say, or some other kind of lawsuit judgment, we can also assign those interests into your trust. So let's talk about too some of the things that may require a little bit more kind of delving into to be sure that it's appropriate to put into your trust. One of the things are stock options. If you do have stock options, then we really do need to coordinate with your accountant, with your CPA, and the plan administrator for those stock options to find out A, should they be placed into the trust? And B, what is the mechanism to do so? A couple of things to remember that you're never going to put into your trust that cannot be owned and retitled in your trust will be your retirement accounts, 401ks, 403bs. Any type of retirement account must be owned by you individually. Now, we may name the trust as a beneficiary of that account, but I'll talk about that in a few minutes because there are pros and cons to doing that. There are certain situations in which we say do not name the trust as the beneficiary. For instance, if you have a surviving spouse, if you have, let's say, either adult children or other beneficiaries who are capable of being able to manage those funds, then it is typically better to leave it to them outright as beneficiaries, named beneficiaries, than to name the trust as a beneficiary and have them receive those funds through the trust. But there can be reasons why we do want the trust to be named beneficiary. For instance, if you have a named beneficiary that you are concerned about managing money, they have a special need, or some reason or they're a minor, or you don't want them to receive that money outright until they hit a certain age, then funneling it through the trust may be the better way to go. And lastly, our vehicles, your car, that ends up staying outside the trust because a trust cannot own a vehicle. It ends up increasing. One of the things it does is it costs you more money because your insurance rates will quadruple in some cases because the vehicle is owned by the trust and is now being insured as the trust. So you do need to be careful about that. Carol?
We have a couple of questions. One
Sure.
is, can you put paintings, like paintings that you've created or personal paintings in a trust?
So you can, and this becomes a little bit of a balancing act when we're talking about those kinds of assets. One thing is if the assets truly do have value to them, and so it's a painting of significant value, you certainly want to make sure you're doing things like insuring it and everything else to make sure that its value is clear. You also may want to actually outline or clarify that that asset is in the trust, and that is usually done with a written document that says you are transferring this particular painting, describe the painting into the trust. But one thing you need to know is the more we point out those assets of value, the more they're also then clearly going to be put on a tax return for an estate tax calculation. And so typically our stuff, our clothing and paintings that don't have significant value would be part of that. We don't include really a value on an estate tax return for. So just realize that if you are identifying an asset like that as having value, that's important because it does trigger your trustee to understand that really does have value and don't just throw it away kind of thing. Same thing with jewelry. Sometimes we have to remind people, that's not cosmetic jewelry, that is really valuable jewelry, and identifying it. But if you do so, you are also flagging it as having value for something like the estate tax return, and it then has to be part of the calculation. Does that answer the question and make sense?
I think so. And then someone else is asking if a vehicle is worth more than the basis for probate, you would want to put it in trust, wouldn't you?
So no, here in Massachusetts, a couple of things to know about vehicles. First of all, if there's a surviving spouse and the decedent, the person who died, owned the vehicle at the time and it wasn't jointly held with the surviving spouse, there's actually a fairly simplified way for us to transfer that asset, that car, over to the surviving spouse without having to deal with probate, without having to deal with anything. If there is no surviving spouse, then unfortunately that asset does remain subject to probate in order to be able to get control over the title of the vehicle to get it to whoever the decedent has directed it should go to, or to have it sold so that the money can be then added to the rest of the estate. It really should not go into the trust, and it causes lots of complications here in Massachusetts, particularly with the insuring of that vehicle.
Okay. And does a boat or RV fall under that as well?
So boats and RVs actually do get assigned as part of our personal property assignment over to the trust to allow the trustee to be able to manage the title. We don't have the same issues with the insurability of them as we do with vehicles.
Thank you.
So how do you go about retitling your assets? So for most of you, when we have assisted with you and you have real estate, that's something that you need to work with an attorney on, is to be able to actually have your deed rewritten and have it transferred from you to you as the owner of your trust. And so I've written out here how we have things retitled is that we put it in the name of the trustee in their position as trustee of your trust, whatever the trust is called. And we typically add the date of the trust, the date it was established. Some of you have worked with us, and you'll see here an example of that. So John and Mary Doe are the clients here. They created the Doe Family Revocable Trust. And so when we're retitling the assets, it goes to John and Mary Doe, or it could be John Doe and Mary Doe, into the Doe Family Revocable Trust. And that was dated January 1st of 2000. And that's how the typical asset holding will read. Now, some of you will find your financial institutions take some shortcuts. They may just say John Doe and Mary Doe trustees. And they should, though, say trustees and then name the actual trust. Sometimes they don't include the date when they're naming it. And that's okay. But typically, you want it to read as the trustees' names in their capacity as trustees of the named trust. Now, some of you have worked with us and may have had a trust previously that we restated for you, that we just brought up to date. And you'll notice when we do that, we still retain the original date that the initial trust was created. And that's because we don't want to disrupt any titling of assets that may have been directed into that initial trust. So for instance, if you came to see us in 2021 and we create a trust for you, and this was a restatement of a trust that you created back in 2000, we will still use the original date in 2000 as the date the trust was created. And we'll just use today's date as the restatement date. So when you are retitling the assets, you will refer to the trust and its original date of creation. So that's important to do and to know, always being taken in the name of the trustees in their position as trustee and the name of the trust and the date.
So Kathleen, how about antiques getting put in a trust?
So they're very much like the painting question. If antiques, again, have value that should be recognized, then we want to make sure that we're clear and we're assigning that antique specifically to the trust. But remember, then you are flagging the value of that antique to be part of your potential estate tax liability after your death.
Okay.
Let me hold off on that conversation about banks for a second. Let me
Okay.
talk about what are called the taxpayer identification numbers, because oftentimes this is something that you're going to get asked about with the financial institution. They're going to say, well, we need a tax ID number for this. When you have a revocable trust and you are the creator of the trust, you are the beneficiary of the trust, then it is your social security number that acts as the taxpayer identification number. And the bank, the financial institution, should put the asset into the name of the trust under your social security number. If you're married, it can be either of your social security numbers, just like your assets are now. So for tax purposes, a revocable trust does not do any separate filing of taxes. It files under your tax information. The only time that we have a separate tax ID number is when we're doing a different type of trust, like an irrevocable or irrevocable trust, a special needs trust, or after the first of a married couple passes. Then we have to break the trust into sub-trusts or buckets, and we have to get an independent tax ID number for one of those buckets. So for this purpose, for your revocable trust, when you're retitling assets, it's your social security number that acts as the taxpayer identification number. So let's now talk about dealing with those banks and what you typically need to do. So you go down to your bank and you say, I've set up a revocable trust and I now want to put my assets into it. Unfortunately, the banks won't just change the name on the account that you have. So if you've got a checking account and savings account, let's say with Middlesex Savings Bank, and you go down to them and say, we have a revocable trust now and want to set up and retitle our assets. The bank will make you create new accounts under the name of the trust. So remember, it'll be in your names as the trustees of your trust and the date of that trust. And then you will transfer the assets from your current account into those newly established accounts. And this should happen without any tax consequence for you. So when we're talking about investment accounts, and let's say you have accounts in mutual funds and some stock, etc., when we transfer that into the trust, there is no cashing out of that asset and reestablishing. It is simply a transfer in kind. So there should be absolutely no tax ramification for setting up the accounts in your revocable trust. But it can get complicated, particularly when we're talking about your working checking account. Most of us have a working checking account. That's the account that we pay all our bills out of, that we get our income into, and that has all of these direct deposits and oftentimes direct withdrawals in it. When you move that account into a trust account, you have to move all of those direct deposits and direct withdrawals as well. So there's a couple of ways that you can approach this. One, just bite the bullet. Know you're going to have a situation in which you're running your current accounts and the new account while it takes time to get everything moved over. And it can take up to 2, maybe even 3 months to move all of those direct deposits and direct withdrawals into the new account. If you decide that that's too complicating and you don't want to do that, then you can continue to keep your working checking account outside of your revocable trust. But know a couple of things. Number one, that account is subject to probate when you pass away. Now, if you're a married couple and you own that jointly together, then of course it will pass to the survivor without probate. but when the survivor dies, it will be subject to probate. Sometimes what people say is either that's fine, it's one asset that will have to go through probate, and that's okay. Other times people decide that they're going to put a named person as a payable on death or transfer on death beneficiary. So let's say you have children and you decide to choose one of them to leave that account to, so that when the second of you passes away, the account will directly go to that child so that they can access it and don't have to deal with probate. Now remember, they'll get the full value in that account, so they'll inherit that full value and they don't have to necessarily share with siblings or other beneficiaries if they choose not to. And they won't have control over that account while you're alive, but if you lose your competency or capacity, because remember, when it's in the trust, if you lose your competency or capacity, your successor trustee will have control over that bank account while you're alive. But if it is in your name alone and outside of the trust, the successor trustee will not be able to control it. So it's just some things to remember about that working checking account. It can be a hassle to get it into the trust, and you can choose to keep it outside of the trust, but there are ramifications for doing that.
Kathleen, can you make the trust a beneficiary of your checking account?
If the bank will allow you to, you could name the trust as the payable on death or transfer on death beneficiary. It will be up to the individual financial institution.
Okay, thank you.
Absolutely. So here's the question about, again, transferring that real property. So this is the house that you own, condo, second home, rental property, and most cases, timeshares. These are done by deed. These deeds are registered with the county that they are located in the registry, the registry of deeds for that county. And so when we're moving them into the trust, we have to rewrite the deed and transfer the property into the trustees' names as the controllers of the trust. A couple of things to know. First of all, when we do that, when we do it for your primary property, we need to not only transfer the property into the trust, but we need to re-homestead it. And just a quick reminder of what a homestead is. Here in Massachusetts, we have a homestead law in which we say that your primary property is so important that we want to protect its value from outside creditors. We want to make it so that if you were sued for any reason, if there was a judgment against you for any reason, we want to protect the value of that primary home. We don't want anyone to be able to force its sale from out from under you and to force you to leave your primary home. Now, of course, there's some exceptions to that law. Number one, if you have a mortgage against your house, the house is what secures the mortgage, so they're able to foreclose on it if you don't pay that bill. If you don't pay your taxes, whether it be local, state, federal, whatever, they also have the ability to take the property for the tax amount owed. And for things like long-term care planning, your home may be subject to a lien if the state ends up paying for your care. But re-homesteading can be really valuable because if you don't actually file a homestead, there's an automatic one of $125,000 for each of us. If you do file, that gets increased to $500,000 for each of us in terms of equity value. And if you're over the age of 65, that increases to $1 million. So filing the homestead is very small money to help protect the value of that primary property from these outside creditors. Oftentimes we're asked if there is a mortgage on the property, your primary home, let's say, or a second home, and you want to put it into the trust. Can you do that? Well, it used to be that no, you couldn't, because in a mortgage contract, there's normally a thing called a due on sale or due on transfer clause. And what this said is, well, if you change the ownership of your home and you have a mortgage on it, then we're going to force that mortgage to get paid off right away. There is a specific act, though, it's called the Garn-St. James Act, or excuse me, Germain Act, that says that when you're dealing with your primary home only and there is a mortgage on it, we can transfer that property into the trust without triggering the due on sale clause. And so when we're dealing with revocable trusts, then we're able to transfer that property in without any concerns about triggering the clause on your mortgage. Now, one thing to know that we have seen with trusts that's a little bit of a complication is if you go to refinance your primary mortgage or to get a line of credit on your property, some lenders don't like to loan to a revocable trust. And so they'll make you take the property back out of the trust, put it just in your names again, do the mortgage paperwork, and then you can put the property back in. And the reason I tell you that is, of course, because every time you do this transferring of the property in and out of the trust, there's a cost associated with it. So you do need to know that having your home owned by your trust, if you look to do any kind of refinancing, mortgaging on that property, they're going to make you take it out. So personal property, we've touched on this already. We assign this personal property. We do a kind of blanket assignment of your personal stuff into your trust. And that makes it so that your personal goods are not subject to the probate proceeding. In your trust document, there's a couple of ways that you can actually decide how you want to distribute that personal property. One is you can actually state in your trust, I want my watch to go to this person. I want this piece of art to go to that person, this piece of jewelry to go to that person. You can be that explicit in your trust if you choose to. Another way to do it is that we can say to the trustee, I may leave a memorandum. And that memorandum can be really in any format. We do give you kind of a blank format that you can use. And basically it says, I want to give this particular piece of property, personal property, to this particular beneficiary. And that then is dated and signed by you. And the most recently dated document is the one that controls to direct your trustee. Another way to handle your personal property is that you just leave it to the trustee and you say to the trustee, it's my desire that the personal property get distributed to the beneficiaries, let's say in equal distribution. And then you're really leaving it up to the trustee to determine the best way to make those distributions among the named beneficiaries. So a couple of different ways that you can handle your personal stuff.
So Kathleen, I'm going to take a minute because we have some questions piling up in the chat box.
Sure.
Someone says that their appraisers say things like jewelry, antiques have two values, that she should insure them for market value. What I should insure them for and market value. Sorry, I read that wrong. What I should insure them for and market value. The latter could be practically nothing when I die if no one wants old things. Is that true?
It is true. So remember, insurance is usually to cover that item, to cover whether it be the perceived value of that item, the replacement value of that item, as opposed to what it might actually sell for on the street. Unfortunately, we find today that a lot of times the next generation of beneficiaries don't want our stuff. They don't want the beautiful wood dining room set that we, coveted and saved all our money to buy years ago. They don't want our china anymore or our silver. They just don't want the stuff. That's really what we're finding. And so many times, when we're looking to kind of liquidate someone's estate, we really find that most things don't have the value that somebody may have thought it had when they were alive. But there's also things like sentimental value too. And that's something that you have to consider is that there's this wonderful study that was done, I believe, by the University of Wisconsin. It was called Who Gets Grandma's Yellow Pie Plate? And it was this whole discussion about this little inexpensive, could buy at the dollar store for, $1.50 pie plate. But everybody loved that pie plate because it represented something more than its monetary value. It represented all the wonderful dinners that were at grandma's house and all of the celebrations and all of that stuff. So you need to be careful about, I see Catherine said it was University of Minnesota. Thank you, Catherine. You have to be mindful of that type of stuff too, that things may not have real value, but they could have real sentimental value.
What about IRA accounts?
So talked about those a little bit before, but let me go ahead and discuss that with you too. So remember, retirement accounts cannot be owned by a trust. They must be owned by you individually. That's kind of the definition of a retirement account. It is an individual retirement account, an IRA. Same thing for 401ks, 403bs, any kind of retirement assets. However, typically it is better to leave those assets to named beneficiaries, particularly if you have a surviving spouse, because for tax reasons, leaving it to the surviving spouse as a beneficiary has much more tax advantage for that surviving spouse. We also recommend leaving it to named secondary beneficiaries when you have no concerns about those secondary beneficiaries. You feel that they'll manage whatever assets they'll receive without any problem, that there's no issue if they were to receive their portion of that retirement plan. But if there is a concern about those secondary beneficiaries, let's say, or primary if you don't have a spouse, let's say someone has a special need, or someone is a minor, or someone is just not able to manage money well for many other reasons. Sometimes people can have, drug or alcohol addiction, gambling issues, just horrible with money. Maybe they're married to somebody who you just don't trust and like, and you want to make sure that their share is controlled for their benefit, but controlled by a third party. Then you may choose to leave it to the trust in order to make sure that the terms of your trust control the distribution of that asset. Now, there are some tax ramifications for that you need to know, not that you'll end up facing, but that the beneficiary, typically it's a higher rate of tax is paid on the money that's liquidated from the retirement plan. But the offset is that the money is controlled and it's being distributed the way you've outlined in your trust.
All right. And then the next couple of questions are about checking accounts. Someone has their daughter on the account, so she can already write checks on it. So they don't need to be put as a payable on death recipient, correct? Because they are joint owner.
So when you name another person as a joint owner on your account, the benefit is that, yes, they have full access to that account. They can write checks on your behalf and they can go ahead and handle that account for you, should you not be able to, or should you just want them to do so. Some of the downsides, though, that you need to know. First of all, remember that because they're a joint owner, when you pass away, they'll get that account completely. Also, during your life, they have full access to that account. And some of you may have heard this story, but I was appointed by the courts about a year and a half, 2 years ago now, for a couple who are in their early 90s, who had unfortunately placed their son in the position of a power of attorney, as well as named on their accounts as an owner. And he ended up absconding with a tremendous amount of money. As a matter of fact, he took 7 of their $8 million. And so it can happen. And so you need to be careful. In most of our circumstances, placing one of our trusted loved ones on as a named beneficiary is not going to cause that kind of problem, but you need to be aware that that is an issue. Another thing is you've got to be very clear whose asset that is, because if something happens to, in this case, your daughter's life, she ends up getting divorced, that kind of thing, there's a potential that the value of that account will try to be dragged in as part of her asset holdings. So that is a downside to having a joint name on that account.
All right. And a third person as a signatory to a working checking account with full access to the account in case you or your spouse pass away, is that a good idea, or is that similar kind of
It's
thing?
very similar. I have not seen a situation in which someone is put on as a signer and not given full control and access over the account, including the ability to take all the value out of the account.
And would that keep it out of probate though?
It would keep it out of probate, absolutely, but it would have the same concerns as naming a child as a joint owner on the account.
All right. If the trust owns your home and you want to sell your home, is that complicated?
So you're just signing all the documents then as the trustee of the trust, but remember, you are the beneficiary of that trust. You are the controller of that trust. So it's just, instead of you signing all the documents yourself, you're signing them as the trustee of your trust, but you still have full control and full access.
Okay. And then a large separate checking account. Oh, could you have a large separate checking account in the trust and then keep your working checking account for typical day-to-day living as it currently is?
So absolutely, you can have whatever types of accounts you want within the trust. Investment accounts, checking, savings, it's up to you what type of accounts you want. And have those within the trust, and you could always keep that working checking account outside.
One last question, and then I'll let you move on. For IRA accounts, both traditional and or Roth, the first beneficiary should be the spouse and the second beneficiary should be the trust. Is that correct?
So always recommend that the first beneficiary be the spouse, except if the spouse is for some reason incapacitated or the spouse is potentially going to need long-term care in the future, then we do some different planning around that. But typically it is your spouse to be named first. And then it depends for the secondary. If the beneficiaries that you're going to name as secondaries are completely capable of managing assets, there's no problem with how they're handling finances, then you should name them directly as the secondaries. If you have concerns and want your trust to control the distribution of that asset, then you name the trust as secondary.
Okay. My trust on financial assets and home says the name of the trust agreement, dated, and the date of the trust. Is that okay?
So typically we want to put it in the name of the trustees. Like most financial institutions won't just put it in the name of a trust. They need to know who's the signer, who is the trustee, because they need to know who has access to it, who's allowed to be able to manage things. So typically we see the name of the trustee in their capacity as trustee for the named trust.
Okay.
So I would definitely just double check with your financial institution to make sure there's no issue.
Okay. And if someone's financial advisor dated the restatement of ownership to the trust, the date he did the renaming, not the date the trust was signed, should they have that changed?
I'm not 100% sure. So you're saying the date of the restatement, not the original date the trust was signed? Again, I'd want to look at the name of the trust, and they really should be following however it was outlined in the trust to be named. So there's no question. So that, because after you're gone, we don't have you here to ask, well, what did you really mean by that? Did you want this in this particular trust? Did you not want it? We want clarity. And so it's important that the financial titling reflect the name of the trust as it's written.
Credit cards, should they be in the name of a trust?
So typically they won't do a credit card for a trust. It's an individual thing. You own it yourself. And so you want the credit card to be in, your individual name. It's not normally in a trust. Just like a corporate card, maybe there's an ability to be able to get one for a trust. I quite frankly have not seen that happen. And I would presume that there might be increased rates, potentially increased fees, like sometimes corporations face when they're utilizing credit that way. So I would recommend that it be in your name alone, not involved in your trust.
All right.
Perfect. So we talked about retirement plans and how they should be named. And again, it is your spouse. If you have a spouse, except in the situation in which the spouse is needing long-term care. And if it is your secondaries we're looking at, if they are capable of managing assets, if you're comfortable with them being able to receive those assets outright, then you name them as the dependent secondary. If not, then your trust. And then your trust needs to reflect how you want those assets managed for those beneficiaries. Are they minor children? Do they have issues with spending money? Are you concerned about divorce? Do they have any kind of special needs? That's when we may consider naming the trust. If you have a question about this, then I really recommend you give us a call to talk specifically about it, because it's really dependent for each individual, each couple, and their circumstances. So when should you take a look at all these documents again? We've talked about how to fund them. Certainly one thing to remember, if you add new accounts, if you add new property, you want to make sure that you retitle those or have them titled at the time of creation or purchase into your trust directly. So if you buy a family home, you want to make sure that you actually have titled that property into the trust directly at the time of purchase. You want to take a look at your estate plan. You want to do that probably every 3 to 5 years. You don't necessarily have to sit down, but those of you who are part of our client care program know that we do that with you annually. But if you're not part of the program, it is something that you want to do on your own at the very least every 3 to 5 years. And certain things that will trigger the need to sit down with a professional and talk about your situation. If there's been a change in your family situation, there's been a divorce, more children are born, grandchildren are born, there's been a death. You want to talk about how that affects your estate plan. Changes in your health, your own health, your spouse's health, the health of one of your beneficiaries, your children, that may necessitate a change to your estate plan so that we can best take care of those beneficiaries and make sure, for instance, a child develops a long-term illness, something like Parkinson's, something like ALS. We may want to change the estate plan so that if that child needs state-funded benefits, we're not disrupting those benefits by leaving them an inheritance. We can still leave them money, but do so in a way in which it's protected, that it's there to provide quality of life needs, but not going to disrupt benefits that they may be receiving from other sources. And asset holdings, you come into an inheritance. Your assets have grown significantly in value. You win the lottery. Those are all reasons to take a look at your estate plan and make sure that it's written in a way that's best meeting your values, your goals, and doing the best around things like tax considerations and certainly the avoidance of probate. Other questions that might be there?
Yes. How does the trust take special bequests for grandchildren out of the trust?
So I'm not sure the question, but if the question is there are already special bequests within the trust, remember this is a revocable trust. You are the one who created it. You have the right to amend it. And so certainly that's an amendment that we can do to the trust to remove that language or to add language if you choose to.
Okay. And if someone needs to do a reverse mortgage on their home, should they wait to put the home's title into the trust until after that is initiated?
So that is what's usually recommended. We would talk with whoever the reverse mortgage person is that you're dealing with or company that you're dealing with. Most of them, again, don't like them in trust situations. They want them in individual names. Reverse mortgages are can be wonderful things in certain specific circumstances. And so I do recommend if you're considering a reverse mortgage, because they have great upsides, for instance, giving you value from your home right away to be able to access for your needs and for your quality of life. But they also can have great downsides. The downsides being that typically they're very expensive, not normally something that you bear, but that is utilizing the value of that property to its fullest and may actually use all of the value. You need to make sure you understand with a reverse mortgage that you need to remain in the property. Once you no longer live in the property, the reverse mortgage is then called. And so want to really talk through the upsides and downsides. Again, they can be very valuable, but they also can have some great risks and downsides that you want to make sure you understand fully.
Okay. And then really quick, can you please speak briefly about what happens when you die, pour over will, and/or assignment dumps everything into the trust?
So remember, the goal is to fully fund the trust while you're alive, to put your assets that can go into the trust in the trust, so that we're not dealing with your will after you've passed away and we're not dealing with probate. But let's say something is forgotten. For some reason, you have either chosen not to put an asset into your trust or you have forgotten about an asset. You forgot you had those individual stock holdings. When you die, the will that you have is typically, again, what we call a pour over will. And what it says is that you are leaving everything to your trust. We do have to deal with probate. So we do have to go to the courts with the will. We have to get the court to authenticate the will as being your last will and testament. And we have to have them give authority to the personal representative so that they can act. Once they get that authority, then the personal representative will gather whatever assets remained in your name alone, and they should then put them into your trust so that the terms of your trust control how they get distributed. Now, of course, with all estates, there are other things we have to look at, whether you have a will, a trust, or both in terms of how your assets get brought forward. We have to look, is there a tax due? Do you have personal taxes that have to be dealt with? Do you have estate taxes that have to be dealt with? And then typically distributions are done by the trust and based on the terms of the trust.
And what if you need some help more than what this video has given us, or this webinar has given us today, like with your trust funding?
So definitely trust funding, that is something that if you find you are having difficulty with it, or quite frankly, just don't want to deal with it, some of the financial institutions, things like ComputerShare can be a real pain in the neck to deal with. That's a service that we offer. And so give us a call. We're happy to talk to you about our fund trusting program, our trust funding program, and how that works and how we can individualize that for your needs. Well, thank you again, everybody. I hope this was helpful. Bye now.